Connecticut has a tenant protective late fee framework with a specific statutory provision that limits what landlords can charge and mandates a grace period. The governing law is found in the Connecticut General Statutes Title 47A, which covers landlord and tenant relations, along with the Connecticut Unfair Trade Practices Act and general contract principles. If you're a landlord or tenant in Connecticut, the state provides clear rules, and the consequences of noncompliance are meaningful. Let's start with the key rule. Under Connecticut General Statutes Section 47A, 15A, a landlord may charge a late fee, but only after a 9-day grace period has expired. If rent is due on the 1st, the late fee cannot be charged until the 10th. 9 days is one of the longer mandatory grace periods in the country, shorter than Rhode Island's 15 and Massachusetts' 30, but significantly longer than the 3 to 5 day standard in most states. The 9-day grace period is mandatory and cannot be shortened by the lease. The lease can provide a longer grace period, but not shorter than 9 days. Any late fee charged before the 10th day is a violation of Section 47A, 15A. Connecticut does not impose a specific statutory dollar cap or percentage cap on the late fee amount. The statute addresses the timing, 9-day grace period, but does not prescribe a maximum fee. However, the general reasonableness standard applies. Under Connecticut contract law, a late fee is a liquidated damages provision, and the fee must be a reasonable estimate of the landlord's actual damages from the late payment. A fee that is grossly disproportionate to actual costs is an unenforceable penalty. What's reasonable in Connecticut? The state has one of the more expensive rental markets in the Northeast, driven by proximity to New York City and strong suburban economies. Rents in the Fairfield County Gold Coast, Stamford, Greenwich, Norwalk commonly range from $2,000 to $3,500. Hartford and New Haven are more moderate, a flat fee of $50 to $75, or a percentage-based fee of 5 to 8% of the monthly rent is generally defensible. Given the 9-day grace period, the landlord has already absorbed more than a week of delayed payment before any fee applies. This means the landlord's actual additional damages from the delay beyond 9 days are somewhat limited. The major cost was already absorbed during the grace period. This context makes higher fees harder to justify than in states where the fee kicks in after 3 days. The lease must clearly state the late fee terms. The fee amount, the 9-day grace period, and the conditions for imposing the fee must be documented in the rental agreement. A late fee that isn't specified in the lease is not enforceable. Connecticut courts require clear written terms. Connecticut's Unfair Trade Practices Act, cut pay, found in Connecticut General Statutes Section 42-1110A through 42-110Q, provides a powerful additional enforcement mechanism. QTPA prohibits unfair or deceptive trade practices in trade or commerce and applies to residential rental transactions. A late fee that violates the 9-day grace period or that is excessive can constitute an unfair practice under QTPA. QTPA provides for actual damages, punitive damages, and attorney's fees. The attorney's fees provision is particularly significant because it means a tenant who successfully challenges a late fee recovers not just the overcharge, but the cost of their lawyer. This changes the economics of challenging even modest overcharges, because the landlord's potential liability includes the tenant's legal costs. Compounding late fees in Connecticut must satisfy the reasonableness standard in the context of the 9-day grace period. Since the fee can't begin until day 10, a compounding structure starts late and has limited time to accumulate before the next month's rent is due. A single one-time fee after day 9 is the simplest and most defensible approach. Daily or weekly compounding adds complexity and risk without meaningful benefit, and an accumulating fee could be challenged as unreasonable under cut PA. The interaction between late fees and the eviction process in Connecticut is governed by the landlord-tenant statutes and specific eviction procedures. Connecticut requires the landlord to provide proper notice before pursuing eviction for non-payment. Under Section 47A-23, the landlord must deliver a notice to quit, typically providing at least 3 days for the tenant to vacate after the notice period. Connecticut's eviction process is moderately paced. The notice to quit, followed by a summary process complaint, followed by a court hearing. The amount demanded must be accurate throughout. Non-compliant late fees, charged before the 9-day grace period or in excessive amounts, can become issues in the eviction proceeding. Connecticut housing courts, which handle landlord-tenant disputes in certain judicial districts, are experienced with late fee issues. Judges scrutinize the calculations, and tenant attorneys routinely challenge non-compliant fees. In New Haven, Hartford, and Bridgeport housing courts, non-compliant fee provisions are identified and addressed regularly. Connecticut provides the tenant with the right to stay the execution of an eviction judgment by paying all rent owed, known as the right to redeem. The redemption amount must be calculated correctly. Including excessive late fees in the redemption amount creates a dispute over what the tenant needs to pay. Connecticut's right of redemption can be exercised by the tenant multiple times, unlike some states that limit the number of times a tenant can cure. This means a tenant who is chronically late can repeatedly pay the overdue amount and stop the eviction. For landlords, this makes accurate fee calculations particularly important because the redemption process may repeat multiple times with the same tenant. Connecticut limits the security deposit to 2 months' rent. The deposit must be held in an escrow account at a Connecticut bank. The landlord must pay interest on the deposit annually. The deposit must be returned within 30 days, or within 15 days if the landlord fails to provide an itemized statement. Unpaid compliant late fees can be deducted, but the deduction must be itemized. Failure to comply with Connecticut's deposit requirements, including the escrow, interest, and return timeline requirements, can result in the landlord being liable for twice the deposit amount. Deducting non-compliant late fees from the deposit compounds the violation and doubles the exposure. For tenants receiving housing choice voucher assistance, Connecticut landlords should not charge late fees when the housing authority's portion is delayed due to processing. Connecticut prohibits source of income discrimination. Landlords cannot refuse to rent to or discriminate against tenants based on their use of housing vouchers or other lawful income sources. Penalizing a voucher tenant for the authority's processing delay creates both a late fee violation and a discrimination claim. Connecticut does not have a major active duty military installation, the Naval Submarine Base. New London in Groton is the primary military facility. Subbase New London is home to the Naval Submarine School and serves as the home port for several submarine squadrons. The base generates military and civilian rental demand in the Groton, New London, and southeastern Connecticut area. Military pay is predictable, and most submarine force tenants pay reliably. The 9-day grace period comfortably accommodates any minor pay processing delays. SCRA protections apply to active duty service members renting in Connecticut. The defense industry beyond the submarine base also generates demand, particularly Electric Boat in Groton, a division of General Dynamics that builds nuclear submarines. The shipyard employs thousands of highly skilled workers who are well compensated and pay reliably. Pratt & Whitney in East Hartford and Sikorsky in Stratford, both major defense contractors, employ large workforces that generate rental demand in the Hartford and Bridgeport areas. From a practical standpoint, Connecticut's rental market is shaped by the state's relationship to the New York City economy, with the western part of the state commanding premium rents and the eastern part being more affordable. Fairfield County, Stamford, Greenwich, Norwalk, Bridgeport, Danbury, has the most expensive rents in Connecticut. The commuter economy to New York drives premium pricing, particularly in Stamford, which has become a major corporate hub. Rents in Stamford commonly range from $2,000 to $3,500. The 5% to 8% range produces meaningful fees on these high rents, but the 9-day grace period means most professional commuter tenants never trigger the fee. New Haven has a diverse market driven by Yale University, healthcare, including Yale New Haven Hospital, and biotech. Rents in desirable New Haven neighborhoods are moderate, typically $1,200 to $1,800. Student late payments near Yale correlate with the academic calendar. Hartford, the state capital and insurance industry center, has a moderate market driven by insurance companies, healthcare, government, and education. The insurance industry workforce, Aetna, the Hartford, Travelers, provides professional tenants who pay reliably. Hartford's more affordable neighborhoods have higher late payment rates. The I-91 corridor, New Haven through Hartford to Springfield, Massachusetts, has varying market conditions. The corridor's manufacturing heritage has given way to healthcare, education, and services, with mixed economic conditions. Bridgeport has an affordable market with diverse demographics. Waterbury, New Britain, and Meriden have affordable markets with varying late payment dynamics. Norwalk, Westport, and the coastal communities have premium markets. Southeastern Connecticut, New London, Groton, Norwich, has a market influenced by sub-base New London, Electric Boat, and the Mohegan Sun and Foxwoods casinos. The military and defense contractor base provides reliable tenants. Casino workers may have income that fluctuates with business volume. One best practice for Connecticut landlords: train your team on the 9-day grace period and enforce it rigorously in your own procedures. Do not charge a late fee before day 10. Even a fee charged on day 9 violates the statute and creates cut pay exposure. Set your accounting system to flag day 10, not day 2 or day 6, as the earliest trigger date. Another best practice: set your late fee at a level that's defensible given the 9-day grace period context. The landlord has already absorbed 9 days of delayed payment before any fee applies, which limits the additional damages from the delay beyond day 9. A fee of 5 to 8% is defensible. A fee of 15% on top of a 9-day grace period is harder to justify. A third best practice: keep meticulous records of every late fee charged. Connecticut's strong tenant advocacy infrastructure, including Connecticut Legal Services, New Haven Legal Assistance, Greater Hartford Legal Aid, and the Connecticut Fair Housing Center, actively assists tenants who challenge excessive or non-compliant fees. CUTPA's attorney's fees provision means that even modest overcharges can generate significant legal costs if challenged. Your records must demonstrate compliance with the 9-day grace period and the reasonableness standard for every single fee. For the complete guide to Connecticut late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.